Good morning. Happy Thursday. I have this stupid camera light, webcam light, face raping me. There's this motion appears to be causing a lot of concern. So I get a lot of questions about it. It's kind of annoying. I mean, it's not annoying to get questions about it, I should say. But it is annoying to have to answer the same question multiple times. So I figured, what the hell? Let's just get rid of this one. Why not, right? Who needs coffee? All right, so this is DeCastro's motion to strike defendants' late opposition to plaintiff's second motion for contempt. Why he's filing this as a motion instead of a reply, I don't know. I haven't really read it yet. People have asked me questions, so I think I know what's in it, but why he's doing this as a motion, for fuck's sake, doing it as a motion isn't the way you want to do this, and the court isn't going to strike it. So, bury the lead there, John. Yeah, the court's not going to strike it. Let's see what he has to say. Motion to strike defendant Catherine Peters' late opposition to plaintiff's second motion for contempt. Now, I just want to be clear that his second motion for contempt is a loser, regardless of whether or not Kate responds to it. But obviously, Kate still needed to respond to it. Plaintiff Jose DeCastro hereby objects to and moves this court to strike Catherine Peters' late opposition to plaintiff's second motion for contempt at ECF 109. In support of this response, is it a response or is it a motion? Or is it a reply? I don't know. He just grabs random fucking words. Plaintiff submits a memorandum of law, which is fully incorporated herein. On January 16, 2023, DeCastro filed. See, now, if you say that you're going to call yourself plaintiff or I, call yourself plaintiff or I, dude. DeCastro filed plaintiff's second motion for contempt at ECF number 103, asking the court to bring judicial notice to this court, asking for this court to bring judicial notice to this court of additional contempt by Peter. Asking for this court to bring judicial notice to this court of additional attempt by Peter. Judicial notice is where a court can take notice as an evidentiary thing. It's an evidentiary thing. Courts can take judicial notice of dictionary definitions. Nobody has to prove them. Nobody has to do anything. The court can just be like, look, the dictionary says this. The court can take judicial notice of maps. Look, Cincinnati's in Ohio. I'm just taking judicial notice of it. Basically, non-controversial things the court can take judicial notice of. I don't know. Again, he just picks words at random. These words have meaning that a legal scholar, a 20-year legal scholar, doesn't understand. The motion was immediately served by the ECF system to Peter. That would be correct. Pursuant to local rule 7.1b2, Peter's opposition was due by January 30th, 2023, within 14 days after the motion is served. Here, Peter's filing the opposition on February 2nd, 2023, multiple days late. She filed it on February 1st, 2023. But maybe DeCastro's in Australia. I don't know. But his point stands. She filed it on the 1st. It was due on the 30th. That's 2 days late. So, yep, absolutely. And I don't think anybody should be terribly worried about it. So there you go. Points and authorities. Oh, you know what? We probably ought to look at share this tab instead. I love that little feature. So we're going to go find 7.1. Motion practice, and he is referring to 7.1b2. 7.1b2, submission of opposition to a motion. A party opposing a motion shall file an opposition within 14 days after the motion is served. unless 1, the motion is for summary judgment. It's not. Or 2, another period is fixed by rule or statute. It's not. Or by order of the court. It's not. So there you go. That's and the 14 days is to include any extra time for service by mail or anything like that. So there you go. She's late. She's late. Everybody scared? Anybody scared? I'm not scared. But there you go. Yeah. So let's continue on with this. All right. A party opposing a motion shall file an opposition within 14 days after the motion is served. The 14-day period is to include the period specified by the civil rules for mailing time and provide for a uniform period regardless of the use of the mails. Here, the last day of 14 days after the motion was served was January 30th, 2023. Peter filed the opposition on February 1st, 2023. Thus, Peter not filed the opposition within the permitted time. Yes. Wish got paid a shit ton of money. He's been paid a shit ton of money. And one of the things an attorney is supposed to do, besides proofread his motions, I mean, even again, Kate's opposition to the motion, even if she wrote it, Wish filed it. And based solely on that, he should have read it, made sure it made sense, corrected the minor errors that were in it, made sure it addressed all the points that needed to be addressed. I mean, he's responsible for it. He was also responsible for preparing it and filing it within the deadline set by the local rules. So Wish, I would never recommend hiring Wish. I'm just going to go. If you're in Massachusetts, Wish does not appear to be a very good lawyer. He appears to be a very expensive lawyer, but does not appear to be a very motivated lawyer to produce results, to make sure that he meets deadlines and things like that. So, I mean, for all the money he got paid, he hasn't produced. So there you go. Rule 6B requires striking of the opposition. Rule 6B1B of the Federal Rules of Civil Procedure, 6B1B. Let's go there. Show this tab instead. I actually hadn't read that, but I had this ready because I knew where I was going. 6B1B. On motion made after the time is expired if the party has failed to act because of excusable neglect. That's 6B1B. Okay. Am I missing something? 6B1B. On motion made after the time expired, up here. Okay. A district court may not consider a late filed response that falls short of the rules of 6B of the Federal Rules of Civil Procedure. Now, this is a quote from a case. A response is typically something that comes from a petition and then a response, not a motion and an opposition. But let's see what we've got here. Load. So this is a memorandum opinion from the United States District Court of Columbia. So it's not First Circuit and it's not binding. So this is on a summary judgment motion. It's filed a motion for summary judgment. An opposition would have required a motion for enlargement. The court struck the opposition, noting that it was untimely and not accompanied by a motion for enlargement. Filed its unopposed motion to extend non pro tunc. Mm-hmm. So these are interesting. Let's see what we got here. It's an abuse of the court's discretion to consider an untimely filing in the absence of such motion. Interesting. Sorry, lots of dead air. It doesn't really affect my opinion. All right. Oh, I wasn't sharing anything. This is what I was sharing, so you could see it. Sorry, I'm not good at this whole thing. It does appear that in this case, which there was a motion for summary judgment. So there was a motion for summary judgment, and the plaintiff filed its motion for summary judgment. So according to this, there was a local rule where they had 7 days or 11 days to file and serve a memorandum of points and authorities in which to oppose the motion. The deadline would have been extended 3 days if the defendant had filed and served its opposition electronically. Federal Rules of Procedure 6D. When a party may or must act within a specified time after being served and services made under mail, leaving with the clerk, or other means consented to, 3 days are added to it. The deadline would have been extended 3 days if defendant had filed and served its opposition electronically. Why would it have been 60 additional time after certain kinds of service? Other means consented to? I wonder what, hold on a second. As it was in 2007. Let's see what the amendments were, because what did it say back then? Subdivision D. We're looking for changed subdivision D. No. All right. We're looking for subdivision D. So that's where the misreading was. So I was wondering how the court here decided that if they served electronically, then it would have extended it 3 days. And then any opposition filed after that date would require a motion for enlargement, evidencing excusable neglect. So, and that's referring to this period, 6B1B, where 6B1B, on motion after the time expired, the party failed to act because of excusable neglect. So the court may extend the time with or without a motion or notice if the court acts, or if a request is made before the original time or its extension expires, or and then if the time has expired on a motion. And that does apply to local rules. Yeah. Peter has not moved for a retroactive extension. She has not. In conformance with the plain language of Rule 6B1B, a court can grant retroactive extension of time only on a motion. Yes, there's that. In the absence of any motion for an extension, trial court has no basis on which to exercise discretion. Here, Peter has not moved for a retroactive extension of time to file the opposition. Incredibly, Peter does not even acknowledge that Peter tardily filed the opposition. Therefore, the opposition ought to be stricken. Yeah, it does appear that the court should strike it. I'm rather impressed. I'm rather impressed. Not with Wish, but I'm rather impressed with Chili for figuring that out. Interesting. Peter's not shown excusable neglect. What constitutes excusable neglect is nebulous, but excusable neglect does not include ignorance of the rules or mistakes construing the rules. You know, if I was Peter, and I'm obviously not Peter, my breasts are not nearly as big as hers, I would have a serious talk with Wish. I would wonder what the fuck my money was doing. Here, Peter does not admit that it was an untimely fight. Does not admit here. Peter does not admit that it untimely filed the opposition, let alone offer an excuse. Thus, Peter is not shown excusable neglect. Rather, it seems that Peter simply forgot to file the opposition on time. Peter's belated opposition comes hours after Catherine Peter read in Discord about people pontificating. The court had not yet ruled on the motion for contempt. The chat on Discord appears to have triggered the belated opposition because Peter filed the opposition less than 24 hours after the chat. There are legions of cases that find no excusable neglect under similar circumstances. I just reviewed the Institute for Policy Studies. That doesn't have anything to do with Discord. This sentence is pretty garbage. I don't even know why he's going into excusable neglect. There's no motion pending. She hasn't asked for it. So, okay. For the foregoing reasons, DeCastro requests court strike Peter's opposition, plaintiff's second motion for contempt. Additionally, if the opposition is not stricken, plaintiff asks for leave to file a reply to the opposition with documentary evidence, as the opposition appears to be full of perjured statements again. Perjured statements. Well, considering that Wish didn't have Peter signed the damn thing or put a declaration in or an affidavit under penalty of perjury, I don't think it's full of any perjured statements. So, oh, sorry, my bad. I'm retarded. All right, we were reading this has not shown excusable neglect, blah blah blah. Conclusion, blah blah blah. So, where are we at? Where are we at? You know what? I am on a laptop again, people. I am on a laptop. I have one screen going. It's dark in here. It's 4:51 in the morning, my time. I haven't had my coffee yet, you ingrateful bastards. Anyway, where are we at? So, good news, bad news. Good news. Chili's motion for contempt was shit, unopposed or not. So I don't believe the court would have granted the motion for contempt, regardless of what Kate put forward. That's number one. Number two, the court is going to read Kate's motion, even if the court strikes it. And the information that Kate put forward in that motion, there was some good information in there. So based on that, the court, you can't unring a bell. You can't unhear something you've heard. You can't unread something you've read. And so it's still getting in front of the court. But yeah, it does appear that Jose DeCastro has a good argument for striking Kate's opposition. And I don't know if Kate watches my videos. I've seen her in a few of them in chat. But my best advice to Kate would be to strangle Wish, metaphorically speaking, choke him, metaphorically speaking, and figure out what the fuck he's doing for her money. She's paid him a lot of money, and he let a deadline slip. I know I've heard a lot of talk about how Kate's representing herself now and she's writing her motions and whatever. But I saw Wish's signature block on that last opposition. And that means that Wish is representing her. And while Wish is in order for Wish to stop representing her, he is not representing her. He is still representing her until he files a motion to be relieved as counsel. I mean, if she's going to go pro se, he has to file a motion to be relieved as counsel, and the court has to grant him leave to be relieved as counsel. So until that happens, or until she hires another attorney, and then basically they could just notify the court that there's a new attorney representing her. She's not talked about going that route that I've heard. But until that happens, until he's relieved as counsel, it's his responsibility to deal with all of this. It's his responsibility to manage deadlines. It's his responsibility to take care of things. Now, I don't necessarily think that this is going to be the worst thing in the world, because I don't think that Chile had a good motion for sanctions in the first place. Motion for contempt. Sorry, words are hard. I don't think he had a good motion for contempt in the first place, but he did fail. This is Wish's fail. I mean, most attorneys that I know of have a calendar. You've got a calendar on your phone. I know some attorneys who have paper calendars, like the year-long calendar in a book, and you put deadlines in there. One of the things that I do all the time is there's a program, a tickler program, and you put dates in there, and it spits out like you print out the next week's upcoming tickler events, and it puts in all the deadlines. This is the last day for discovery. This is the last day to close expert discovery. This is the day where you have to do expert disclosures, etc. So that's part of being an attorney, is putting those in there. That's so it's a little rough. It's a little rough. I predict a Wish v. Merb lawsuit. I don't think he's gonna sue me. He missed the fucking deadline, dude. Like that's not defamatory. That's he literally fucked up. So a phony law scholar can tie up the courts on a whim. Great system we have. I don't think this is really tying up the courts. Wish is a high-paid lawyer with incompetence. He definitely is not. He definitely is not doing his job. He's definitely not doing his job. I haven't seen anything out of him that that makes me believe that he's worth the $50,000 that he charged. And there's a loophole in everything. Everything can be fixed, even missing the SOL date if you toll it. Well, there's not always a loophole in everything, Miss Stedman. There's not always a solution for everything. A potential solution is that she would file a motion for leave to file her late opposition, and then get it in that way. I mean, even if it gets to it. Can Kate sue him for failing to represent her in good faith? I don't know if he's failing to represent her in good faith. That's a weird way of putting it. Normally, the standard is deviation from the standard of care. There's two things that you need, though. At least in California, I've only done malpractice suits against attorneys in California, so you're going to get a little bit of California law. California law, suing an attorney is next to fucking impossible for malpractice, because number one, they have to have done a deviation from the standard of care. They have to have failed. Number two, that has to have cost you something. And number three, in order to prove it, you have to basically prove, like a trial within a trial, that but for the attorney's malpractice, you would have come out better. You would have prevailed. You would have, like on a civil case, you have to prove that not only you would have won that civil case, but for the attorney's malpractice, but you also have to prove how much you would have won, because that would be your measure of damages. And you have to be able to prove that you would have been able to recover it, actually enforce the judgment. So can she sue him? Yes. Is it a viable lawsuit? No, because she hasn't lost this yet. So number one, she doesn't have a measure of damages. And number two, she would have to prove that but for him missing a deadline opposing a contempt motion, that she would have somehow been better off. When it comes to high-powered attorneys, they sometimes adopt the attitude of, if someone will pay what I charge, then I'm worth that amount. Well, a lot of times, yeah. A lot of attorneys are out there, and they're, it's business, and you get paid to do the job. And a lot of it's going to be what the people in the area are charging. But yeah, I mean, I get it. Like in the Bay Area here in California, you see attorneys charging like a couple $100 more an hour than what they charge in the greater Sacramento area. But they also have a lot higher expenses. Leases are higher, wages for paralegals and stuff are higher. But yeah, I mean, he seems to have gone out of his way to make a lot of money for not doing anything. The amount of money to fight an idiot like Chili is astounding. The amount of money that Kate has spent she's Kate, for all that Wish is fucked up and not given Kate what she's paid for, Kate hasn't managed Wish. She has not managed Wish at all. She hasn't set expectations. She hasn't enforced those expectations. She's allowed him to control the litigation. Now, to an extent, you have to trust your attorney. My mantra has always been, never trust an attorney unless it's your attorney, and always trust your attorney. And maybe my mantra is wrong. Maybe I shouldn't say things like that. She wanted a 12B6. She wanted out, and she let Wish do things that weren't getting her out. She let Wish file a response instead of filing an opposition. And the rationale for it was that if it was something like if he filed a response, he wouldn't have gotten additional 21 days or whatever to file a new amended complaint. And I remember that. I remember hearing that. I thought I did it on a stream, and it just amazed me that the guy did not understand. He didn't even bother to look it up and check it out, because he was going on a like a 10 or 12-year-old version, maybe even older than that, of the Federal Rules of Civil Procedure, and it's not like that anymore. So going back to Cali, nice. Damn, that's a lot of money. Absolutely, that's a lot of money. Wish just isn't a good value for money. No, he's not. Better call Saul. Saul's not a real attorney. She basically got an expensive, slimy, high-charging lawyer. Yeah, I mean, she got the legal equivalent of taken to the cleaners by him. Wasn't the contempt motion dismissed anyway? No. I'm not saying he was doing his job. I agree with you. I'm just saying that there are ways to try and fix it, like a motion for leave. Yeah, I mean, you could try to fix it, but the odds of the motion for leave getting granted at this point, since she's already filed the opposition, he's already moved to strike it, and then she goes in to file one, I mean, her odds of getting it granted are lower and lower. She should have got Chile to represent her against Chile. Sure. She's lucky she didn't use mine. $13.50 an hour. Right, dude. Right. I only trust first-year family law attorneys. That's probably not a good idea. We're just as bad as everybody else. I need a new lawyer. Mine seems to have stopped working, but a replacement did well last time. Well, that's good. He was probably a viewer and knew how much money she got from her fans. You know, there are attorneys out there who generate their funds based on how fast who generate billable hours based on how fast a client is willing to pay, about how much effort it takes to collect. My understanding is that Kate was like, just all the money that she got, she was just slamming into his retainer. So she was basically telling him, she was saying, look, I've got all this money and I intend to spend it. And so based on that, there are a lot of attorneys out there who are going to take that as a signal that they have basically free reign to bill. And a better way, a way that I suggest that people retain attorneys and maintain their attorneys, is to, number one, only put in as much into the retainer as the attorney is demanding. Don't advertise how much money you have. Only put in as much money as the attorney is demanding. That's number one. Number two, review your bill and question it. If Wish's retainer was, let's say it was $5,000, he's probably not going to sink a lot more than $5,000 that first month. Why? Because that's all he's guaranteed to getting paid. If he spent $50,000 that first month, and then he handed her a bill for $45,000, then she would be very reticent to pay it, unlikely to pay it. And Wish, as a businessman, because he is a businessman, he's an attorney, he's going to be cognizant of that. He's going to say, well, look, I'm not going to just blow $50,000 this first month, or however much he blew. He's going to be like, I got about $5,000 plus or minus. I might be able to get away with a little more, depending. I might get away with a little less, but he's going to maintain that. He's going to maintain that sort of thing. So don't put more money into the retainer. That's number one. Than the attorney's demanding. And number two, actually review the bill and question the attorney. If something doesn't look right, if you see it, like I've seen some of her billings, and like just a block, like 5.7 hours to do like 10 different things: research, read emails, respond to emails, watch a video, blah, blah, blah. You don't know what the attorney did. Like, you have no idea what he did. I'm not saying that my billing is the best by any stretch of the imagination, but in my billing, I break it down. I spent, 2/10 of an hour reading this case. And I'll actually tell you the case I read, because that way you can like open up the case and you can see that it's like 15 pages long, and you'd be like, okay. It took you 10 minutes, 15 minutes, whatever to read it. Yeah, I can understand that. So, but just having that just like 5.7 hours, I mean, you don't know what the fuck the guy did. You don't know what the guy did. All right, I have no idea where we're at. So we need to hire attorneys because they know how to navigate the system, but we need to supervise them. If we knew how to supervise them, we don't need them. No, that's silly. That's nonsense. You need to hire attorneys, yes, because they know how to navigate the system, yes. But you need to supervise them, yes. They're working for you. You're paying them. They're your employee. For all intents and purposes, they're your employee. I mean, obviously, they're an independent contractor, but yeah, you need to supervise them. You need to set the expectations. Yes, absolutely. Like, if you hire an engineer to do something, like if I hired a guy to come out and fix woodpecker damage, right? When he got done, the first thing I did is I walked and I looked to see what he did to make sure it was done right. I don't know how to fix the woodpecker damage, but I sure as shit know how to look to see if it looks right. And if it doesn't look right, Kate didn't need to hire. Need is a funny word. Dear Abby could have won this BS. Okay, Tom, why don't you go ahead and start writing her pleadings for her. I love this format. Good job. Research. Absolutely. That's quite bold of you to say about that man. It sucks if you're right. Well, I mean, you've seen the evidence. I've been fairly critical of Wish since pretty early on. I've told you, I told everyone via these videos that I've done that giving him all that money up front, he's just going to spend it. I said that in a previous video. I don't remember which one, but I mean, it license to spend money, dude. Like, why would you do that? Flat fee representation is trying. Not for me, dude. Good luck with that. We're on you, Wish. Pack it up, boy. Yeah, good luck. Yeah, connect the dots. Wish versus Merv will be great. Good luck on that. McCartney saying paperback writer to me. How apropos. Okay. I think Kate was trying to be transparent with people who donated to her legal fund, and it backfired on her a bit. She might have had 3 people to oversee the funds going to Wish. Should have had 3 people to oversee funds going to Wish. Well, I don't know how crowdfunding legal representation is always a concerning thing. I do agree that she was trying to be transparent. She did post bills for people to see. If you haven't seen it, then I don't know, go to her Discord. I've seen people sharing copies with me, so I know she shared it on her Discord. but yeah, it was silly. Like she was saying something like she like as soon as she got the money in, she just give it to Wish, and it's like I mean, I get it. You're trying to be transparent, but cut off your nose to spite your face. That's why robot lawyers are a great idea. Sure, Merb's brain would win. I got $100 on that bet. Brain win against what? Why didn't she? I'm not licensed to number one. I'm not licensed to practice in Massachusetts. Number two, I'm not interested in going out there to represent her. At least not until we've had sex, because obviously, you can't have sex with a client, and so I need to have sex with her first in order to represent her. That's really the long and the short of it. I can't believe anyone would donate money to anyone involved in this nonsense. I agree. When I go to the doctor to have a new test done, I always follow up and never wait for them. Yeah, I mean, inspect what you expect. You want to see the bill? I've seen it. He did show the retainer bill facts. Yeah. Me too, Denise. Yeah, it's your responsibility. I mean, this is important. Like this is Kate. Kate is getting sued. Like she needs to make sure that the guy she hired for the job is actually doing the work that she's paying him to do and not doing extra work. I'm sending gold bars. Good for you. I agree, Melissa. Gold bars. Show anyone's video, stop it, comment, restart it. That is what every reaction channel does. That is what every prank channel does. Every news channel. That is what YouTube does. Her lawyer is a joke. Well, that's an interesting take on everything, Tom. I believe that when she hired Wish, it was for a defamation lawsuit defense. So, I mean, but yes, the current complaints about copyright infringement are similarly stupid and egregious. Well, if she agrees with your assessment of her performance, then could she not get the remaining of her retainer back? Number one, you assume there's a remaining retainer, and I don't think that's a good assumption. If I know Wish, considering the amount of effort that he put into that last opposition, which appeared to be somewhere between slim and none, I'm going to guess she's out of her retainer. All I'm saying is heads need to roll. No, there won't be a remainder. That's correct. There will not. Oh my God, I'm dying. Are you sure there's room? Yeah, I give her credit for fighting the insanity. Well, I mean, she didn't really have a lot of choice. I mean, I wouldn't get too wrapped up in white knighting for Kate. I mean, I don't know if I'm the only attorney out there who was like cautioning her on this. But I'm not licensed to read or write, neither am I. I love you too. It's really prison bars, but I'm painting them gold. Good. How is a retainer a bill? Well, so the way I practice, the way my personal practice is I have the retainer. The client comes in. Let's say it's a $1,500 retainer because I'm cheap. I am the crack house version of an attorney. I'm not a Benjamin Wish. And I don't retain people who could typically afford to spend $50,000. So the retainer is like $1,500, generally speaking, and I bill against that retainer. And so at the end of the month, if I have a bill for like $500 or $1,000 or whatever it is, then I pay myself from the retainer, and then I send them a bill to replenish their retainer. So it's basically like a prepay. The retainer is like a prepay. I don't know if that's the question you were asking, but that's how's a retainer built. I mean, that's my best answer for you. Yes, Kate did show the receipts in Discord. I saw a screenshot of her payment, but I never seen a receipt or a bill. Not that I'm claiming there aren't any. Well, I've seen them. If her ambulance chaser had motioned for summary judgment on the very first day on fair use, even an appeal on a loss would have been no worse. Tom, I don't think you're a practicing attorney. It doesn't sound like you're a practicing attorney. I'm going to suggest that you stop giving advice like that because it's not very good advice. If he had motioned for summary judgment on the first day on fair use. That wouldn't have gotten him very far, considering on the first day it was a defamation lawsuit, and it wouldn't have been a motion for summary judgment. It would have been a 12b6 or some similar thing. But you keep trying, Tom. Go to law school, buddy. You can do it. The bill was revealed for the entire. Yes, it was. You don't get the retainer. You don't even get the retainer back. No, you don't. Seen that. Not white knighting for, but at least she tried. we put a little too much effort in the. At least she tried. At least a person tried. There's sometimes discretion is the better part of valor. Sometimes. Yeah. So I mean, it's like giving Chile credit for trying. Well, at least Chile tried to sue Google. I mean, I'm not buying it. Oh, it shows a lump sum. No lump sum. Don't you get the retainer back? If it's not used. But boy, howdy, an attorney of Wish's caliber will be able to use any remaining retainer if there is any at this point. Merb is not the Wish version of Wish, is what I'm gathering. No, I am the Wish version. I'm the much cheaper alternative, I guess. And I definitely don't have as nice of an office. I'll guarantee you that. She tried and will get my cash again if needed. Chili is a fool. Well, okay. Nice. I love crack house attorneys. They give great value and they can score me some good weed for when I'm out. Absolutely, brother. Chili's trying to drive this case into the ground on motion practice, but he's still going to have a bitch of a time demonstrating that he suffered over $750,000 from literally anyone. Well, you know what, Paul? I agree, but we're not in diversity jurisdiction anymore. With the federal, it is a federal tort now, copyright. So the $750,000 is moot. Had they motion 12b6 or challenge the not 12b6, it would be a subject matter jurisdiction challenge. I'd be like 12b1 or 2 or something like that. Had they done that initially over the damages, then maybe. So they have to maintain the retainer. With my clients, yes. My clients, they replenish their retainer every month. I gave my lawyer $2,500, and so far he's only used $500. Case is closed, so I will get the $2,000 back remaining. Yes, if that scenario is correct, then yes. If it's done, demanding a ruling on fair use would have ended it out of the gate, or YouTube would have to be shut down. You go, Tom. Again, that law school money is paying off well for you. I meant that initial retainer is not a bill because there have been no services rendered at that point. I mean, if we want to like play semantics, maybe. I don't really know, don't really care, but I'm just going to go ahead and say, sure, you win that round. Support to Min Law School. Okay, seems like Mr. Wish. Yeah, she was an ATM. Chili's an idiot. Yes, we know. Try reading the amicus brief. They're messed up too sometimes. Sure. Then you have to retain lawyers who retain. $500 for him to talk to me on the phone. Now case is dismissed. Lol. If you're billing against retainer, is it replenished? Yes. Well, if they don't replenish it, then I end up not representing them fairly soon. $75,000. Wow, is that really what she spent total? Jesus H. Christ. Is your office in the back of a nail salon? No, it's in a small. It's a small office that I rent out of an office building that has another much larger attorney's office in it. And retainer lawyers, okay, right? If you are constantly replenishing a retainer fund, then you would always end up getting a refund at the end. Well, if there's money left, but as soon as the I mean, just trust me. I mean, Wish could spend the money before he gets it back. Just trust me on that. Merb's office has 4 tires from time to time. No massage parlor. I wish. This little suit is only copyright, or does it also include? Right now, it's just copyright. My female divorce attorney gave me back all of our used condoms. Boom, boom, pants. Absolutely not. Tom, do you go to the University of Phoenix Law School? If you did, you'd probably have a bit better legal take. Lowell, write your profession. We keep it going until the money dried up. Absolutely. Damage claim. Is this about that gay guy? I think Chili's gay, but I mean, he might just be autistic or something. I don't know. All right. I can't figure out how Chili subs keep growing on both channels. Always buying them. Anyway, so we've reached the end of the comments. Thank you for watching. Have a great day.